All rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. It's the time set for oral argument in State against Merwin. Our cause number is 1CA-CR 16-0260. Counsel, we are fully aware of the issues in the briefs and have conferenced the case before coming in this morning. Today's argument will be audio and video recorded and made available online to the public shortly after the argument. Each side has 20 minutes for oral argument, and the appellant is free to allocate that time between primary argument and rebuttal as you wish, subject to watching your own clock. So if you're ready, we can begin.
May it please the Court, my name is Rhonda Neff, and I represent the criminal defendant and the appellant in this action, Mr. Paul Merwin. There are three main issues that Mr. Merwin raised on appeal. The first one, whether the trial court erred in raising inevitable discovery under a type of inevitable discovery not previously raised by the state at the trial court level. The second is whether the police had exigent circumstances, as it's now been affected by the Habitone opinion. And the third is whether the state presented sufficient evidence to warrant a conviction in this case. I think that with the primary basis right now being on the exigent circumstances and the inevitable discovery, I'd like to start with the two of those unless the court would like me to start somewhere else.
Go ahead.
I'd like to first address the Habitone opinion. I know we did some supplemental briefing on it. The state's argument in there was that the language in Habitone still makes Cocchio apply to a medical blood draw, allowing for exigent circumstances to contain dissipation of alcohol alone. I disagree with that interpretation of it, but I think that we also have a major distinction in this particular case because in this case, Mr. Merwin was not subjected to a proper medical blood draw. And the trial court found that the medical blood draw was not proper. So there's an inevitable discovery issue, and whether inevitable discovery then corrects the medical blood draw for the purposes of Habitone. But
well, just before we leave exigence, though, I mean, let's say we agree with your interpretation. It seems pretty clear at the time that a very fair reading of the Arizona Supreme Court's jurisprudence on point was that there could have been exigency. And isn't that enough to at least remove exigency from the equation under the good faith exception?
I don't think so. And the reason I don't is because the court, in its interpretation of 281388E, has specifically required that there be probable cause, exigent circumstances, and a proper medical blood draw that's attached to that.
Well, I'm not getting to element 3 yet. I'm just talking about number 2.
Correct. And if you interpret it the way that makes the dissipation of alcohol alone be sufficient for exigent circumstances under a medical blood draw, it alleviates the need to even have that as an element. Because the very reason that the medical blood draw exception gets raised is because they have probable cause to believe that somebody has been drinking. In that case, exigent circumstances would always exist. There's no reason to have a second requirement of exigent circumstances if, in fact, really what the court is saying is that it really requires probable cause and that it be drawn by medical personnel for medical purposes. The fact that there's an actual requirement of exigent circumstances, I think, makes it more understandable when you look at Schoenberger and some of those other cases, that in fact it is a warrant exception, not something that is entitled for the state to use just because they don't want to seek a warrant.
Exigent circumstances may depend on the level of intoxication and the circumstances of the arrest too. If you arrest somebody who's just fallen unconscious in a bar amidst 20 beer bottles, one could argue quite reasonably that there is time to get a warrant. In
Correct.
this case, the exigence may have appeared more real because of the lower, ironically, because of the lower level of intoxication that they might have suspected.
Well, I think in this particular case, the only, it kind of goes into the probable cause argument, but the only real evidence that he had that alcohol could play a factor was the slight odor of alcohol that he smelled in the car and the fact that an accident took place.
Didn't they also have, there was no braking, driving slowly? Wasn't the evidence that, doesn't that also suggest impairment?
I don't believe so. There was some disputed testimony on whether there was brakes applied. One witness did testify that she believed the brakes had been applied previously. I believe that Officer Nestor testified that there was no evidence the brakes had been applied.
But he swerved like he was trying to pass somebody in front of him when there was nobody in front of him. I mean, this seems to me there's probable cause. I mean, probable cause doesn't seem to me to be your strongest argument.
No, by far it's not our strongest argument. Probable cause is very easy to meet.
You lost me on the exigent circumstances a little bit. Are you saying that even if there was a question about exigent circumstances before Havatone, before that, the good faith exception wouldn't apply? Is that what you're saying?
That's correct. The exigent circumstances argument is somewhat complicated because of the Havatone language, and I don't think that the court was overly clear in how to interpret how it was reading Kokio in that particular opinion. But I certainly understand that exigent circumstances exist based on dissipation of alcohol. There's plenty of jurisprudence that says that it can, in fact, warrant an exigent circumstance. However, the jurisprudence also says that warrant exceptions aren't something that are to be used just because it's easier for law enforcement. It's based on a true exigency. Now, the medical blood draw exception, in my opinion, is no different, albeit under, as Havatone went through it, one of the considerations as it went into the medical blood draw exception was the fact that there was a lesser intrusion into the defendant because medical personnel were invading their veins and not police officers. In this case, it was the officer that directed the medical personnel to then withdraw the blood,
Again,
which I think...
I understand, but I'm trying to figure out the exigent circumstance. So the exigent circumstance is, well, what did the police know was exigent circumstance at the time of this? And you're saying it really wasn't, given the case law, and there wasn't a good faith exception? Is that what you're...
Well, on one side of it, I think the record's not clear on it, but to answer your question, yes.
That's what Havatone held, there was no good faith exception?
There was no good faith exception that was permitted in Havatone.
But at the time all this occurred, recent Supreme Court cases that have disavowed Havatone had not yet come out. And it seemed...
I'm sorry, you mean not disavowed Havatone?
No, I'm sorry, disavowed Kokio.
Right.
Yeah, had not come out.
Well, there had been case law in Scherberger and Flanagan previous to the blood draw in this case that had certainly come out and indicated that exigent circumstances for a blood draw required a case-specific analysis. So that was well known to the officers at that point, or at least should have been, which was, again, one of the Havatone issues that was raised, that there was nothing out there, even in the reading of Kokio at the time, that came out and made a blanket exception that in medical blood draw cases, dissipation of alcohol is always an exigent circumstance. There still has to be some kind of case-by-case analysis that determines whether or not exigent circumstances exist in that particular blood draw. And in this case, Officer Nestor and his testimony during the suppression hearing shows that not only did he not have exigent circumstances, but I'm not even sure that he knew exigent circumstances was a requirement for a medical blood draw. And at the time, that's consistent with the policy that was going into the different police agencies and stuff like that, that exigent circumstances exist on dissipation of alcohol alone. Supreme Court has now said that that's not sufficient. I think that in this particular case, Officer Nestor testified that he smelled the faint smell of alcohol very quickly after he got to the scene, which would have been shortly after 6 p.m., and he was at the scene, he talked to people, could have got a warrant. He followed him to the hospital, he could have got a warrant. He got to the hospital and immediately asked the medical personnel to draw his blood. He had the opportunity to get a warrant. It wasn't a situation where exigency truly prohibited him from getting a warrant. It was his choice not to get a warrant. And I don't believe that that is the principal reason why we have an exigency type warrant exception. when a warrant can be obtained, it should be obtained. And in this case, it could have been obtained, and the officer chose not to.
That's fair enough, but nobody's arguing, I think, that simple exigency is enough here, right? I mean, the facts are more complicated than that.
Well, under the state's argument, I think that they are arguing that dissipation of alcohol alone is sufficient under the Kokio paragraph within Habitone, and I think that is a blanket exception that they're arguing.
Not now. At
Well, I
the
guess
time
we're
this
going to see
occurred.
in about 10 minutes if that's what they're arguing.
But they may argue that at that point in time, that was enough.
Well, and certainly after the Habitone opinion, the state knows better because the Supreme Court's made that a little bit clearer. But again, even in the Habitone opinion, as it relates to medical blood draw, there is still some question on whether or not this blanket exception to the dissipation exigency still exists. The Habitone opinion speaks very clearly as it relates to
But
the
pre-Habitone, are you suggesting that you would have had a decent argument on that with under the facts presented here, with the smell of an odor of alcohol, slight odor, with the circumstances that are discussed, no breaking, and some other evidence of impairment? With that, without Habitone, would you have an argument?
Yes, I believe that we would.
Successful argument?
Yes. Well, I'd like to believe it would be successful.
Go ahead and finish the answer to your question, but I don't want to detain you so long on this that you don't get to inevitable discovery.
Okay. I think that the reason that we still would have had a good argument on that is because Schoenberger, and I might have pronounced that wrong, and Flanagan had already come out making a case-by-case specific analysis. Nothing in Kokio specifically said that case-by-case analysis no longer applied as it related to medical blood draws. So I believe that we still would have an argument even predating Missouri v. McNeely and Kokio. As it relates to the inevitable discovery, the inevitable discovery doctrine as it was raised by the state at the trial court was inevitable discovery based solely on ARS 281390, which allows medical personnel to go in and get medical reports of blood taken during medical treatment. Not even an issue in this particular case because it never happened. So even if they could have obtained those records under inevitable discovery, they would not have provided the concentration of blood and THC of which the state used primarily at trial. The the inevitable discovery wasn't raised at all during the suppression hearing. State never raised any kind of an inkling that they were even going to consider it.
The court said something about it.
At the time of its order, but not really during the suppression hearing itself. Neither party raised it. The trial court, you're right, did come out in its order and say that while it could be argued under inevitable discovery, it could not think of any reason or case law that would support a finding of inevitable discovery in this case. In response to the judge's order, the state then filed a motion for reconsideration arguing, in fact, there is something that would allow inevitable discovery to apply to this case, and it's ARS 281390. That is the only issue of inevitable discovery that the parties had the opportunity to brief, because the inevitable discovery argument that was ultimately determined by the court at the end of the motion for reconsideration.
So we should ignore that the court was wrong when it said, I can't think of any, besides 1390, the court was wrong when it said, I can't think of any other basis for inevitable discovery?
No, the court was absolutely right when it said inevitable discovery didn't apply under any circumstances or cases that it could.
Yeah, but it later said something different.
Well, it later indicated that, I guess, if the medical personnel were going to draw the medical blood draw anyways, that I guess inevitable discovery can apply. Right. I still don't think the facts support that conclusion because the nurse testified that consensual medical blood draw in the hospital requires consent of the defendant. There was no evidence of consent.
Who requires that?
The hospital.
The hospital. We're not here to enforce hospital policy, though.
Well, no, but if the state is going to rely, or the court's going to rely on a finding that a medical blood draw would have in fact occurred,
right.
A prerequisite to that was consent by Mr. Merwin under the hospital's policies.
Consented when he came into the hospital generally to all treatment, and he was free to revoke that consent at any moment, but he didn't revoke.
He was. However, there was a separate consent form required specifically for blood work.
Administratively by a private entity. That doesn't seem to have the same effect as a law.
I would agree, but under an inevitable discovery argument, the court has to consider whether that evidence would have inevitably been found. In this case, if Mr. Merwin had had the opportunity to object to that paperwork saying, I consent to have blood work done by the hospital, no blood would have been taken from him.
But he had the ability to object to the needle being used to take the blood. He could have said no at any moment. And he didn't.
I don't know that he could have at that point. I mean, the officer had just directed them to take it.
No,
But you're suggesting he might have if the hospital had put a form in front of him. Why is that different than him just saying, I don't want my blood to be drawn? Why does he need to have a form in front of him to say that?
Well, he has to have a form in front of him in order to consent to it, certainly. But I think
he did.
But you agree that he initially consented to any type of treatment?
He consented to treatment at the hospital, yes, albeit it was somewhat.
If the hospital didn't have a separate form, you would agree that would encompass drawing some blood?
I would think if they didn't require it as a separate form, yes.
They didn't tell him at the start that we have separate forms for X, Y, or Z. It's having a hard time getting past the kind of blanket consent to treatment.
And I would agree that there is somewhat of a blanket exception to consent. Had the nurse not specifically indicated that this hospital requires a separate consent form to be signed if blood work's to be conducted, I would say generally when you go into a facility, you would consent to that form of treatment, or if you didn't consent to a particular form of treatment, you would voice that.
Which he was perfectly able to do because he was conscious. He knew that blood was being drawn. He could have objected. Even and if he had objected, then that would be a separate issue. I mean, he may have worried that the police directive would override his objection, but certainly if he had objected, there would have been no consent.
Correct.
Right? And then at that point, inevitable discovery becomes more difficult to argue.
Correct. And if I may, I'd like to reserve the last 3 minutes.
Very well.
Thank you.
Hello, my name is Terry Christ, representing the state of Arizona, and may it please the court. Beginning with the exigent circumstances and good faith issue, in 2012, at the time of this search, officers could reasonably rely on the binding precedent in State v. Cosio for the proposition that they did not need a warrant to obtain a sample of the medical draw. In fact, this court...
I guess the problem I have with that is there have been fax machines burning up all over Arizona for decades, getting warrants in these cases. And if Cosio really meant you don't need a warrant because alcohol is always going to dissipate, have the officers just been wasting their time with these warrants?
Well, it does seem under Cosio they're not necessary. This court wrote just a year and a half ago in State v. Reyes that as of 2012, when Reyes' blood was drawn, Arizona courts had uniformly held that dissipation of alcohol in the blood was in itself sufficient exigent circumstances for purposes of the medical exception.
I guess though I have trouble taking that and extending it to the notion that up until very, very recently, you never needed a warrant to draw blood in Arizona. That is not consistent with law enforcement practice. It's not consistent with our case law, which we have many cases dealing with warrants in blood draws. It might be a little too facile just to go from there is some exigency to you never need a warrant.
Well, I don't know if you would never need a warrant in all DUI cases of all sorts, but at least in medical draw cases, I mean, I've done, I don't know how many of these cases in the last 3 or 4 years now, and I've never seen one where they applied for a warrant. So I'm sure there has been at least some police practice going on without warrants in obtaining medical draws in these sorts of cases. And that is what COSIO says. COSIO does mention that exigency is one of the 3 requirements, and then very quickly follows up by saying, yes, we need exigency generally, but you're always going to have that in these cases because you have the natural dissipation of alcohol. And then this court, multiple times since then, has reviewed medical draw cases. Take the State versus Lind.
Why is a medical draw different than one where they're not taken to the hospital for some other reason? Why is the dissipation issue different?
2 responses to that, Your Honor. The first is because Havitone tells us they're different. And that's at least important for purposes of stare decisis. But also, Havitone and COSIO make the point that medical draws have a lesser intrusion. And when you read COSIO, COSIO reaches the conclusion that the lesser intrusion is relevant by citing to a U.S. Supreme Court case, Cupp versus Murphy. And in Cupp, the police took a scraping under the fingernails of a suspect, and that was found to be permissible under the exigent circumstances exception. And when the court was analyzing that, they considered the fact that the fingernail scrapings were a lesser intrusion. So the degree of intrusion is relevant when deciding whether we have exigent circumstances, and both COSIO and Havitone acknowledge that. So we have Havitone that comes out just a few weeks ago that makes the same point. Havitone generally found that Schmerber didn't authorize warrantless blood draws, but then said we have COSIO. We're not going to overrule COSIO, but we think COSIO only applied in the context of medical draw cases. And that's enough for us to be bound by the precedent that, at least within the medical draw cases, COSIO was valid for that proposition in 2012. Of course, Neasley, which also came out recently, says COSIO doesn't stand for that proposition going forward from this point on. So it is not our position that, following the U.S. Supreme Court's decision in Missouri versus McNeely, that dissipation of alcohol would be sufficient exigent circumstances anymore. That was only true pre-McNeely in 2012. So I think we, from that, can arrive at the conclusion that if we have a medical draw case and we have the dissipation of alcohol, that's enough to show exigent circumstances, which brings us, of course, to the other question in this case, whether this was really a medical draw case. And we submit that it was. And the inevitable discovery doctrine gets us there because, given the testimony of the nurse, given the fact that a doctor actually had ordered a blood draw, it was inevitable in this case. There would have been a...
Counsel, when was McNeely decided?
I believe it was 2013.
So
It was
after the draw in this case?
It was after the draw in this case, yes. So because of that, we have the good faith exception under Davis for binding precedent. And we submit COSIO is the binding precedent that we would follow here. So as for the inevitable discovery doctrine here, we have the testimony of the nurse assistant saying we were absolutely going to draw blood from this patient, given his advanced age, given his apparent injuries. We have the fact that a doctor, in fact, did order a blood draw. And from that, the trial court made a factual finding that it was inevitable that we were going to have a blood draw in this case. And we don't believe there's waiver of that claim on appeal for a couple of reasons. For one, the trial court sua sponte brought up generalized inevitable discovery in the order granting suppression, but incorrectly stated that he didn't think the inevitable discovery doctrine applied without some specific case authorizing it. Of course, we don't need that. Inevitable discovery is a general Fourth Amendment principle that could apply in a case like this. But also, the court more openly made the point when reversing itself in the motion for reconsideration order that inevitable discovery applied. And defendants' argument that this somehow surprised them and deprived them of an opportunity to present facts on inevitable discovery also simply isn't the case. The argument the defendant apparently wants to make here is that somehow it wasn't inevitable that defendant would have consented to the blood draw. The problem with that, for purposes of at least notice of their opportunity to defend, is the state's argument in the motion for reconsideration is that under ARS 281390, they inevitably would have been able to get a copy of the toxicology report from the hospital. We're not raising that argument on appeal, but I think what's important to keep in mind is both that argument and the more general inevitable discovery argument share the same set of facts. They both suppose there would have been a medical blood draw.
I've seen the state argue pretty strictly, and we've been pretty tough on defense counsel, that if you don't argue something below, we're not going to let you argue it on appeal. State comes in and files a motion under 1390 and says inevitable discovery under 1390, and now you're saying, well, we shouldn't be held to that. That sounds like it's what the rule that holds for defense counsel doesn't hold for the state.
Two responses to that, Your Honor. Firstly, the rules are designed to be somewhat asymmetrical with respect to the state and the defendant, because on appeal, it's the defendant's burden to show error. On the state has already secured a conviction. This court affirms for any reason supported by the record. And then my second argument.
If it was made below.
Yes, and the trial court sua sponte brought it up. The defense certainly had an opportunity to litigate this point. And because you have the same shared facts between the 1390 argument and the 1388E argument, they both suppose that there would have been a medical blood draw. They certainly had the opportunity in responding to the motion for reconsideration to make the point they want to make now is, hey, we never would have had consent.
They don't have that burden. They don't have the burden of arguing, responding to something the state didn't raise. The state says we are entitled under 1390 to get the blood reports. And you're saying the defense there, because of that, had to also argue, well, they don't get the, inevitable discovery doesn't apply to get the blood tests, the blood samples?
I don't know if they would have to respond to the entire generalized inevitable discovery argument, but at least they're put on notice with the set of facts that would apply to both. And of course, this court in other cases has held that when a trial court sua sponte brings something up that the defendant didn't, we don't have waiver or forfeiture. I've had cases where we couldn't argue fundamental error when the defense didn't raise something, but the trial court brought it up anyway. And so the thought was, well, everybody had an opportunity to litigate it, so no one's prejudiced. Mm-hmm. So I think an overly mechanical application of the waiver rules there would be unwarranted. And of course, we have the constitutional prohibition of reversing cases for technical error. And I think it would be nothing but a technical error in this case to find waiver against the state when we know all the facts and that this was something that could have been litigated.
To find waiver against a defense counsel who doesn't raise something.
I think if there were actually a inability to argue the case on appeal because facts weren't fully litigated at trial, then we'd have a reason to apply waiver. But that isn't the case here.
Okay.
The facts, especially for the good faith argument, which they also bring up for waiver. Good faith is a legal argument in the concept of Davis. There's really no facts. It doesn't matter whether the officer knew he had good faith reliance. It doesn't matter if the officer knew that exigent circumstances were a requirement. Under Davis, good faith is an objective inquiry, and so all we're looking at was what was the state of binding precedent at the time of the search and what did it authorize. So definitely for good faith, I don't think waiver is appropriate, but also for inevitable discovery. The other point I would make is even if the court were hesitant about inevitable discovery, I think the court actually could find here that there was a medical draw and that the trial court simply got it wrong. The trial court's order doesn't make a factual finding that the blood was not drawn for medical purposes when the officer obtained it, that it was a police draw. That's not what the order says. The order says that the court isn't sure. The court can't make up its mind. It doesn't think the state met its burden. But that's a legal question. That's a sufficiency question. And courts review those de novo. I think this court could look at the testimony of the nurse assistant saying we were definitely going to draw blood. This court could look at the doctor's order actually requesting blood and could reach its own conclusion that the original draw obtained by the police was a medical draw. So I think this court could go...
Aren't those two different arguments? I mean, one is, was the draw that was done a medical draw? And the other is, would a medical draw have been done anyway?
Yes, Your Honor.
Those are two different points.
That is true.
We could say, no, this was not a medical draw, but it would have been inevitably discovered because they would have had a medical draw.
Absolutely, Your Honor. They are separate arguments. They're both two
it's sort of a
ways.
stretch to say, because they said, well, we would have done it anyway, that means that this was a medical draw.
No, I agree. And the other evidence we actually have at the suppression hearing is we have the testimony of the officer who walks in and he sees them already drawing blood. And then they ask him, do you want a portion of that sample? And he says, yes. And we also have, in addition to that, the fact that given the age and the medical history, that this guy, protocols actually permitted them to draw his blood without a doctor's order. And the factual hang-up for the trial court appeared to be that the doctor's order for the blood occurred a few minutes later than the blood draw itself happened. But we had a nurse come in and talk about that too, saying, well, that sort of thing happens all the time. It's an emergency room. Sometimes the doctors will verbally order us to do something and then we'll go back and fill out the form later. So
The court did say the state had not met its burden to show that it was a medical draw, right?
Yes, the court did say that. I think that's a de novo review here. I think the court could reevaluate the evidence and say that.
You'd want us to reweigh the evidence and come to a different conclusion.
I think the court could take the evidence as is and just say it amounted to meeting the state's burden. I don't think it requires us to necessarily reweigh it just to.
There's contrary evidence, right? There's evidence going both ways.
Well, I'm not aware of any contrary evidence. There were a few things the court cites that gave it a little bit of pause to whether it would. The court apparently thought that the police officer was a little equivocal in his original statement of what happened, and then he gives the story I described in a second. I actually don't read those as inconsistent. I read it as the police officer giving a more summary account the first time and then just elaborating on what he said the second. Okay. But again, none of that's necessary if we go with the inevitable discovery doctrine. They're just two alternate ways of arriving at the same result. And the trial court did make a factual finding with regard to inevitable discovery that we think was correct and should be deferred to, in that they credited the testimony of the nurse saying we definitely were going to draw this guy's blood. And I think the problem with the idea that he wouldn't have consented to it is we simply have no reason to think that's the case. There's nothing suggesting that he declined consent to any sort of treatment. There's nothing to suggest he knew that they required a separate form for blood draws. There's no suggestion the only reason you might think he even would deny consent would be to deprive the police from getting his blood. And if there were 2 draws, he already had given the police blood. So there's no reason to even think he would have declined consent for a second draw if there were 2 draws instead of 1.
Do we have to get there? You already consented.
No, I don't think we do. I think it's just even more reason to think that we have consent in this case. So if the court doesn't have any further questions, we would respectfully request that it affirm the convictions and sentences. Thank you.
Thank you.
Again, I'm Rhonda Neff. I'm representing Mr. Merwin. I want to start with the premise that this court can reweigh what the trial court has already done in finding that this was not, or the state failed to meet its burden as it relates to this being a medical blood draw. This court and other courts have given deference to the trial court's factual findings and its weighing of the credibility of witnesses. And in this particular case, the trial court did find that the officer's testimony was inconsistent as one of the reasons why it said that at the time the blood was drawn, it was not for medical purposes, or at least the state had not proven that it was for medical purposes.
You do have those 2 arguments. I mean, one is that it was or was not a medical blood draw. The other was that it inevitably would have been.
Correct.
So are you just focusing on the first of those right now?
No, I think that it goes into the inevitable discovery as well, but...
How so? How does reweighing the evidence go into a inevitable discovery?
Well, in weighing the testimony and whether the state can show that it would have ultimately had a blood draw, I think the court, that's before the court, certainly as raised in one of the issues.
And the court determined that it would have inevitably gotten a medical draw, a blood draw, right? I mean, that's what the court held. Correct?
Yes.
Inevitably, there would have been a medical. And so do you want us to reweigh the evidence and say, no, the judge was wrong, the evidence doesn't support they would have been inevitably drawn blood?
I think that the court doesn't even have to reweigh necessarily that particular portion of it, because I don't believe that the court properly found inevitable discovery under an issue that was not raised by the state.
That goes back to the waiver.
Right.
Okay.
Isn't waiver different, though, if a court rules in your favor, and you have 5 other reasons that you think would support the court's ruling? Do we require you to put on those other 5 reasons? It seems fundamentally different. If the court rules against you, it seems like you lose your opportunity, or you waive your opportunity to explain that there is a reason for going the other way. But if the court's ruled in your favor, it seems like it's hard to find, whether you're the defendant or the state. It seems different than the obligation to put forth an argument when the court's ruled against you.
Well, in this particular case, the court did rule against the state, and the state didn't raise the argument. It raised a completely different argument under 281390. Right. That's the issue we have as it relates to the court's consideration of inevitable discovery, is the defense presented its reasons why 281390 didn't apply, because we were under the indication that the court had already found that inevitable discovery under a broad premise did not apply to this case, and the only issue raised by the state then fell under 281390.
It's not a situation where a party raises 5 issues
Correct.
and the court rules on one
Correct.
and in its favor. I mean, in this case, the court ruled against it, and the state only argued one exception.
Correct. And with that, I'm out of time unless you guys have questions.
All right. Thank you very much for your arguments. Matter is now under advisement. We will issue a written decision in due course, and the court stands adjourned.